Hi, good morning, everybody. Welcome to this webinar on the Whistleblower Protection Act 2024. And I'm delighted to welcome everybody on behalf of Dialogue Solutions. My name is Axel Kravatsky, and I'm a director in Dialogue Solutions. And I'm also an international expert with ISO representing Trinidad and Tobago in developing standards on corporate governance in general, including this one, 37002 on whistleblowing. And I'm delighted to welcome in this webinar Donna Jackson-Hill, and who is the chair of the Trinidad and Tobago Transparency Institute. Donna has 33 years of experience in accounting, treasury, risk management, and so has a lot of experience with compliance, with risk management, and with enabling organizations to do the right thing. And she has been leading the Transparency Institute now for 6 years. And so we are delighted to have you join here. We're also going to be joined by Andrew Samuels, who's a colleague at the ISO. He's also the founding director of Whistleport Compliance, which is also a partner of Dialogue Solutions. So Andrew is leading Dialogue Solutions whistleblowing service. And now technology has favored him, and he has been able to join us, and we can see him.
And I will talk about technology with genuine authority very soon. Thank you for waiting.
Very good. So we're going to have like about 4 segments in today's webinar. So the time is tight, and so we'll start right away. We are going to be led off by Donna, who will lay out the general picture of the role of whistleblowing and the importance of whistleblowing in the context of Trinidad and Tobago. And I will then dive into some details, great details relating to the Whistleblowing Act. Then Andrew will zoom out again briefly to put this act into wider global perspective, including other regional developments, and then zoom in on the actual implementation of a whistleblowing system. And then I will join again with providing an overview of the services that Dialogue Solution provides in this space as an integrated solution that brings all these factors together. And we then welcome also an interactive question and answer segment. And along the way, please feel free to add your questions in the chat, and we will address them. The webinar will be recorded and will be shared, and subject to any technical glitches. And so without further ado, Donna, may I invite you to speak and to present us with a picture of the importance of whistleblowing from your perspective. Thank you.
Thank you very much. And thank you, Dr. Kravatsky and Mr. Samuels, for sharing this platform with me. And let me say good morning, ladies and gentlemen. It is indeed a pleasure to have this opportunity to address you on this World Whistleblower Day 2025. So happy World Whistleblower Day. As Dr. Kravatsky said, we are going to look at understanding why whistleblowing is an indispensable tool in the fight against corruption and a key element of effective oversight. I am Donna Jack-Hill, chair of the Trinidad and Tobago Transparency Institute. I've been on the board for 6 years, but holding the seat as chair going on, this is my 2nd year. So Trinidad and Tobago Transparency Institute is a non-partisan, non-profit organization established in Trinidad and Tobago in 1998 as the national chapter of Transparency International. Transparency International is a global anti-corruption network functioning in over 100 countries. Our raison d'etre is to stop corruption and to promote transparency, accountability, and integrity at all levels and across all sectors of our society. What a tall order. And having set that lofty vision, we may have also set ourselves up for criticism, as it is not uncommon to hear, what transparency doing about corruption? Or, if all you're fighting corruption, why Trinidad and Tobago still so corrupt? Well, I must concede that these are fair inquiries. Hopefully, at the end of my discourse, you will understand the Institute and what we do a little better. So corruption is a complex phenomenon, always expanding and evolving. It is not a static or simple problem. Corruption is adaptive and shaped by economic, political, social, and technological changes. Because of this, there is no magic bullet to combat corruption. And what is required, in our informed view, is an ecosystem of anti-corruption measures which work together to deter corrupt actors from perpetrating their corrupt practices or exposes the corrupt practices when undertaken. So you may ask, what should such an ecosystem look like? We at the Institute posit that it should contain a solid foundation of laws and policies necessary to define corruption, criminalize it, and establish enforcement standards. Those of you familiar with the Institute's work may remember our advocacy for the establishment of procurement legislation, our calls for campaign finance reform, and for the establishment of whistleblower legislation. We also see a role for independent oversight institutions whose function it is to secure accountability and investigate corruption without political interference. And these bodies are, for example, Integrity Commission, Office of the Auditor General, Office of Procurement Regulation, Office of the Ombudsman, and Financial Intelligence Units, amongst others. The ecosystem should have a free and independent judiciary where courts are impartial, well-resourced, and capable of upholding the law fairly and consistently. Rule of law and fair trials are essential to justice and deterrence. Another aspect of the ecosystem would be effective law enforcement, which consists of trained, well-equipped police and investigative agencies that are insulated from political influence. There's a role for non-government actors, the civil society groups, and the media, who play a watchdog role by exposing corruption and mobilizing public pressure. The media, labeled as the fourth estate, is expected to act independently as a vital pillar of the democracy to hold power to account and to inform the public through in-depth, independent investigative journalism. And the all-important political will and ethical leadership, where leaders are committed to fighting corruption and leading by example through, inter alia, transparent appointments and decision-making, no interference in investigations, asset disclosure by public officials, and enforcement of anti-corruption pledges. There's a role too for us, the citizens, as public participation and education. Through those two things, citizens should be informed, engaged, and empowered to demand accountability. A culture of integrity must be built from the ground up. and whistleblower and witness protection mechanisms, as people must be able to report corruption safely and confidently. The fear of retaliation silences witnesses and protects corruption. Now, my mind has been pregnant with thoughts on the approach and content of my presentation today. And as I drove home from the Institute's office on Saturday, heading east on the Churchill Roosevelt Highway, I saw the Office of Procurement Regulations whistleblower billboard. I don't know how many of you are familiar with it, which is just before the Macoya wholesale market. A billboard I have seen several times, I am sure, but my gaze fixated on the slogan, "Silence is corruption's best friend. Speak up and stop it now." So, how often have you said, or have we said, or heard someone say, "Everybody knows where the corruption is," or "Everybody knows he or she is corrupt"? The statement, "Success in corruption eradication is not about what you know, but what you can prove," reflects a critical truth in the fight against corruption. Knowledge or suspicion alone is not enough. It must be supported by credible, admissible evidence that can withstand scrutiny in investigations, courtrooms, and public opinion. Corruption is notoriously hard to prove because it's hidden by design, facilitated by complex networks, and protected by fear, silence, and retaliation. Whistleblowers, especially insiders, have access to information that may never reach authorities or the public through audits or external oversight alone. In other words, whistleblowers expose what formal oversight often misses. A credible source of information which leads to investigations to unearth evidence to prove illegal or harmful practices will, in the first instance, ensure that perpetrators are held accountable, but may also serve as a deterrent once the likelihood of being caught increases. Many of us will appreciate the benefits that will redound from being able to unearth instances of wrongdoing in the public and private sectors, of misuse of funds, bribery and embezzlement, and the existence of unsafe practices in the workplace, as well as human rights violations, as this will have direct impact on safeguarding resources and preventing harm to human lives. Additionally, identifying wrongdoing through whistleblowing may force organizations to investigate and strengthen their systems, resulting in more effective and responsive oversight systems. Despite these benefits, in small island states such as ours, the fear factor of stepping up and speaking out is magnified. And many have adopted the "drink water and mind my business" mantra. In a Transparency International article published on June 20th, 2025, entitled "From Policy to Practice, Building Whistleblower Systems That Work," it states, and I quote, "Holding power to account can be a dangerous act. Courageous individuals who expose the harmful acts of governments, public organizations, and companies often face risks, including harassment, blacklisting, smear campaigns, and in some cases, even physical violence, persecution, or arrest. However, they keep working to enhance transparency and accountability to ensure public funds go where they should. End of quote. Like Transparency International, this has been the reason why whistleblower legislation has been a key advocacy initiative of Trinidad and Tobago Transparency Institute. The legislation is meant to bring protection through the force of law and the systems it prescribes to whistleblowers and to ensure that employers in both the public and private sectors establish mechanisms to protect the whistleblower. The Whistleblower Protection Act 2024 has been nearly 10 years in its making, since the introduction as a bill in November 2015. The Institute waits in hopeful anticipation of its proclamation. However, in the meantime, exploring practical ways to translate the requirements of the Whistleblower Protection Act 2024 into systems that work is the next step. And the key reason why the Institute has partnered with Dialogue Solutions Limited to explore this transition. Like you, I am looking forward to the rest of this morning's discourse. However, let me take this opportunity to invite you to join us at Trinidad and Tobago Transparency Institute as we participate in building out and strengthening our country's anti-corruption ecosystem through our advocacy. I thank you. And I pass the floor back to Dr. Kravatsky.
Thank you very much. Thank you very much for your presentation. And I would like to focus and highlight what you have said in terms of the importance of having the ecosystem and the importance of enabling all the parties to do their bit. And this legislation is one of those crucial elements. It is important also for the companies themselves, so the organizations, state or private, to have clear guidance for how they should handle these things. What is the regulation about it? In addition to, of course, protecting the whistleblowers themselves. But in my experience, having worked with many organizations throughout the Caribbean for the last 15 years and implementing governance and ethical management systems, the actual procedures of doing the right thing, of how do we organize, what is the role of the board, what is the role of management, what is the role of the whistleblowing officer. These things are not self-evident to many places, and they get stuck at the most fundamental things. So having the guidance of the legislation, of course, it is more than just guidance, but having, at the moment, it is still not in force, but we have clear procedures with it, and they lay a common foundation that is internationally accepted. And Andrew will also then highlight how using ISO 37000 and associated systems, you can implement these things. So let me quickly now come to a detailed overview of the Act itself. And so I'm going to go fairly quickly, and you will receive the presentation and the materials and the recording. So it has three main points. It's about protection. The fact is, it is that it has been passed by Parliament last year, but it is not yet enacted or not yet in force because it has to be promulgated. And its objectives are to encourage disclosure. Overall in the Caribbean, we have underreporting for exactly the reasons that Donna has spoken to. It's the legal legislative environment is not as conducive and is not as developed. But in addition to that, many organizations, their internal processes and policies and training are not up to mark. And so also people inside the organizations or outside the organizations who could be whistleblowing do not feel sufficiently protected. So encouraging disclosure, protecting the whistleblowers, and regulating the process so that that is clear, transparent, and can be trusted. A few key terms in this process is there are designated authorities. The appendix, the schedule to the legislation lists, I think, 21 organizations that are external bodies to which people can whistleblow. A disclosure is information showing improper conduct. We're going to look what improper conduct means, that it has occurred, is occurring, or is likely to occur. Okay. An employee is somebody who is connected with and working together with, pay or no pay. Employer is somebody who is engaging others to achieve an aim. I'm rephrasing it, of course. The act is what the act says stands. And also, by the way, of course, anything I say here does not constitute legal advice. You know, it's just my interpretation of it. And whistleblowers are those who are disclosed to a whistleblowing reporting officer or the whistleblowing unit inside the organization or outside the organization. The protected disclosure, not all disclosures are protected. We're going to talk about the exact conditions that need to be fulfilled. And there are internal disclosures, those that you're making inside the organization to the whistleblowing reporting officer, that organizations shall have. And then you have external disclosures to those reporting units under certain circumstances, again, described in the law, and we'll talk to it. And those 21. So detrimental action, you're protecting disclosures from detrimental action, which is employment consequences, personal mistreating, or material harm, which are also defined in the Act. And what constitutes improper conduct that is either ongoing or likely to happen? And so it is criminal offenses, that anything that violates the law in Trinidad and Tobago, legal failures to carry out obligations. So if your compliance obligations that are likely to result in a miscarriage of justice, safety, environmental threats, financial misconduct, discrimination, and retaliation, as well as concealment. So it's a broad definition, and in each case defined. I already spoke about the fact that there are internal disclosures and external disclosures, and that basically one can escalate to an external disclosure if the internal one is not yet in place, or if the person, the whistleblower, believes that he cannot trust the internal system, he or she, then they can make the disclosure to the external whistleblowing reporting unit. What are the qualifying criteria? It must follow proper procedure according to Section 6. And for example, that one of the things is that if you are making a verbal disclosure, so you go to the disclosing to the whistleblowing officer, and you report in person, verbally or by phone or any other means, but then that can be made, so that is not prohibited. But the person receiving the disclosure needs to write it down, and then the person making the disclosure needs to sign the statement that has been recorded. Okay, And it has to be in good faith, without malicious intent. It has to be a reasonable belief. It is not for personal gain, and it must comply with the internal procedures. And it must be properly made under the if you report externally according to section 14.5. So the important thing here to note is that there are circumstances in which the disclosure is not protected. But overall, I would say the act is pretty clear that it is meant to be broad and it is not meant to catch people out if they miss a detail. And for example, if it uh, so there are remedying factors as well along the way. Limitations, false information, legal privilege is maintained, so, and anonymous disclosures. Now, when it comes to anonymous disclosures, um, uh, they are generally not protected. So what happens is that it is confidential, but it is not anonymous, right? And so that is why you have the whistleblowing officer, you have the whistleblowing, the reporting entity, and you have services such as Dialogue Solutions, which are neutral in this space and that are able to maintain the conceal the or keep the identity of the uh, reporting whistleblower confidential. And there are many instances in Trinidad and Tobago where this actually has worked. And so it is not impossible to maintain the confidentiality and maintain the identity of persons, even if it is a small society, as long as the processes are well established. And now with the introduction of technology, this has become really quite easy to do. But what we will argue here is that simply buying any form of technology that allows you to make these reports in itself is not sufficient for you to either comply with the act or to have a good practice. Okay? It's just a necessary element that most organizations will have. So the internal disclosure mechanism means that you need to have to appoint an officer to this. This doesn't mean that you have to hire somebody new, but inside your organization, who is the whistleblowing reporting officer, right? And they must be receiving and processing internal disclosures. Now you can designate an external officer to be your for the internal disclosures. That is to say, you are going to receive and decide on how you're going to process this, how you're going to act on this whistleblowing. So you're not using the external service. You're not using an external reporting entity. It's still internal, but you can hire a body to act as that agent for you, that officer for you. You must establish procedures for how this is being done, and you must notify the whistleblowers of the status. I think it says 30 days is internal and 45 days in the case of the external one. And you must refer when necessary. So after you assess the veracity of the disclosure, then you must determine what to do next, and you need to come to the correct result as a defensible result. Why do you dismiss it, or why are you going to investigate it, and what are you going to do next? Okay. Externally, you have the whistleblowing units, and these whistleblowing units are following the same kind of procedure. In addition to that, they must report to the ministry to which their line ministries. They must report to them in terms of what activities have taken place throughout the year. It is not to disclose the individual cases, but you need to know what is happening, which is the same thing as any organization the board of directors, the governing body of any organization, should review its the functioning of its whistleblowing system, which doesn't mean tell me who whistleblowed, but I need to know that it actually works. In many organizations I work with, these are topics that is out of scope and doesn't understand. The governing bodies are not aware or are not fulfilling their duties, just good governance duties in this respect. So when can you do the external disclosure? So even though you have an internal, or it's still maybe being developed, but let's say you have one, once you have put it into place, you can still escalate and go externally. And if you don't have internal procedures, if you're not getting a response in reasonable time, if you have conflicts, if you think that the persons to whom you would be reporting inside the organizations may have a conflict of interest, there is great urgency or risk, and you are concerned about preserving the integrity of the evidence. All these cases enable you to go to the external body. The external procedure is that you make the submission, 45 days, the body has time to review, and then they need to, within 45 days, they need to respond to you. And there needs to be notification and also a potential referral for next steps, whether it is police investigation or whatever the right next step might be in this process. The protection, what are the core safeguards? So it is protecting against detrimental action, legal immunity, identity protection, and civil remedies. So these are important additions to the ecosystem that the legislation brings, which currently do not exist. Now, it is in the interest of good governance of any organization, and governance meaning to direct in order to generate value, to oversee and to account for how the organization was directed and overseen. It is in the interest of every organization to have a whistleblowing system in place, even if the legislation is not yet in place. Because otherwise, a serious element related to oversight is missing. But the legislation, to Donna's point, is really complementing the ecosystem and creating that legal basis upon which, through which you are going to be further protected. But if you apply ISO 37002, then the organization can take all the measures. Once it is committed in implementing the system, then you will also benefit from protection, but you wouldn't have similar remedies or legal immunity. Now, exceptions to the immunity. If you yourself are the perpetrator in what you are contributing to it, this is not a jail-free card, right? Basically, and there are civil and disciplinary considerations as well. But in other words, when your case is going to be reviewed, let's say you were part of it, the fact that you were whistleblowing, the legislation makes provision that the legal proceeding should take that fact into account that you were whistleblowing. For confidentiality, we need to protect identity. We need to protect the confidentiality of the content. It needs to be shared for investigation, and there needs to be clear guidelines for communication. So the Act specifies that these things should be in place, and the organization's duty now is to put these mechanisms into place. What exactly are the procedures that you will, through which you will ensure that this happens? What exactly are the terms of reference of the reporting officer and all this? So Andrew will speak to that and emphasize that the most robust way in which you can do this is to use ISO 37002, and if you so choose, work with Dialogue Solutions to give you an all-encompassing solution that also includes training in this process. Okay. So whistleblowers can also appeal to High Court if they believe that they have suffered or are likely to suffer detrimental action. So, and there's also interim protection possible. So this, again, is emphasizing the part that Donna was making in creating the ecosystem that is enabling, encouraging, and gives confidence to whistleblowers to speak up and act in the interest. So if you're hindering disclosures, that is a $15,000 fine and or 50,000. So the penalties are also in place. And if you are breaching confidentiality, then it's $600,000 and 2 years in jail. Obstruction, 15,000 plus up to 2 years, and document tampering also $30,000. So the act is making it very clear in terms of that these things are not tolerated. And that means that the processes for the officers and the organizations implementing these aspects should also be watertight, unless you want to expose yourself to these fines. And in the process, I mean, the only reason to have the fines is to be able to protect the
whistleblower.
And the administrative provision, so there are ministerial powers and there's a regulatory framework that the ministry or the legislation can also further put into place. So that is not yet there. And hold on, in section 21, we have these. In the schedule, we have these 21 designated authorities. And they belong into 3 broad groups. So those related to financial oversight, legal justice, governance, and environment. All of them are mandated to establish these officers and units so that whistleblowers can report to them. And so this is the mechanism through which an alternative in some other countries, there could be an ombudsman, there could be a single organization that has this role and function, but this is the mechanism in which it was implemented. So the main concern to be able to have something external to the organization is provided for. Okay. So this was sort of an overview of some of the facts and details relating to the legislation. And I will now attempt to invite Andrew to present his part. And for that process, I will have to just briefly stop sharing here and bring up his presentation. And
Axel, do you want to see if I can share my screen with the presentation?
Yes, please go ahead. It would be great.
Have you got it? Can you see my screen?
No.
Let's try that again. Can you see it now?
No.
Okay.
Let me share mine.
Yes, please.
Okay.
Okay. I can't see the presentation. I see your initials on the screen at the moment. Can anybody else see the presentation? It might just be mine because Teams and I have a sort of an unfriendly relationship sometimes, I think it's fair to say. Can you see it, Axel?
I can see the presentation.
Yeah, we can see the presentation.
Okay, well, if you guys can see the presentation, I've got it in front of me. So
Okay.
I'm going to go from there. So firstly, thanks, Axel, and thanks, Donna, for the presentations and the insights. And I think One of the things about going third on a panel like this is I've got the ability to be able to adapt part of what I'm going to talk to here to kind of build on the good information that's been provided so far. So I look at whistleblowing from a slightly different lens in that I've always come at it from an organisational perspective. Now, I think one of the things that struck me from Donna's presentation are the lofty ideals, if you want to put it that way, for Transparency International. I think they're the right ideals. And I've really trying to take that lofty position, but from an organisational perspective as well, to demonstrate the value of whistleblowers and whistleblowing. And so over a 10-year period, I've been implementing whistleblowing solutions. I started off at HSBC, moved to Barclays, where we actually prevented the CEO from unmasking a whistleblower on 2 occasions just daily. All of this is in the public domain. But I knew based upon that we built controls that could really work. And I'm going to take a slightly different talk to whistleblowing as well, because one of the key things I like to talk about when it comes to whistleblowing are the economic benefits. And I use a carrot cake analogy. So whistleblowing is a very personal thing for people to do. I think it's not just about your ethics, but it's also about building empathy. And I'd like to talk about being authentic. So I'm going to give a quick introduction via one of my authentic stories that I believe, Axel, you're probably quite sick of hearing. But it's about carrot cake. And I tell my daughters to eat vegetables, and they say, yes, Dad. And then they go and eat carrot. They'll go and eat cake. So we started baking carrot cake for them, knowing that they would get carrots and vegetables, and they thought they were eating the cake. And I think whistleblowing is often like that within a good governance framework as well. We can talk about the benefits of whistleblowing. We can talk about a 2.8% increase in return on assets. We can talk about a 20% reduction in legal fees. And that gets people interested. What I've found over a decade is talking about the moral reasons for doing it, the right reasons for doing it, tends to be met with a nod, an agreement, but generally not always the call to action that we'd like to see. So I'm trying to think of whistleblowing in a different kind of way and trying to get organisations to adapt it because they see the benefits of doing that. And if the ethical benefits follow that, then I'm absolutely happy with that as well. So Axel, are you able to go down to the next slide, please? Okay, so after I left Barclays, after we prevented the CEO from unmasking people, I got involved with British Standards Institute. And up until that point, like a lot of people, I thought ISO had 9,001 and 27,000. I did not realise what a rich world of standards there were out there. But I quickly found out. And so from the end of 2016 onwards, I've been involved with the development of ISO 37,000. And so I'm quite passionate about this. I think there's a lot of benefit to using it. So ISO 37002 is what we would call a guidance document. That means it's more of a framework that can be applied to organisations of any size, any shape, any sector, any size, any jurisdiction. Okay, and I think that's really important as we look at the Caribbean, as we look at Trinidad Tobago, and as we look at the bigger global picture as well. But in short, it was put together with 161 experts from 35 countries with 7 liaisons, of which Transparency International played a part in that as well. And they were made up of people from business, from government, from unions, from civil society, and actually whistleblowers themselves. And I've blown the whistle in the past too. And a lot of people have, even if they don't realise that. But what we've got out of this, I think, is probably one of the best ISO frameworks that's relatively simple to understand, relatively easy to adopt if you've got the right understanding of it, to provide protection to organisations and protection to whistleblowers. And I want to make clear, and I'll put this later on in the slides as well, that you cannot protect an organisation if you're not protecting your people, and your people aren't protected if the organisation's not protected. So there's that virtual, that circle of trust that gets built when it comes to building out whistleblowing reports and whistleblowing systems. Now, ultimately, it's based upon principles of trust, impartiality, and protection. And there's 4 stages in a whistleblowing life cycle. So there's receiving reports, assessing reports, addressing reports, and concluding reports. And the intended outcome from the standard is we want to encourage organisations to facilitate reporting on wrongdoing or suspected wrongdoing as well. We want to support and protect whistleblowers, but not just whistleblowers, other interested parties as well. So building on that, you take into account people like to talk about malicious reports. So what if somebody does raise a malicious report about another person? That person deserves due protection, due process, as much as anybody else within there as well. So we talk about protection to whistleblowers, but we do need to think about protection to the subjects of the concerns, witnesses that are involved in it, be that suppliers, be that family members. It takes a slightly wider view to make sure that everybody is fully protected. We want to make sure they're dealt with in a proper and a timely manner. Okay, I think for a lot of whistleblowers, it is a stressful situation, and so they don't want to hang over their head for a long time. And I think it's our obligation as people who help whistleblowers and support whistleblowing programs to make sure that we're both transparent and set expectations for how we're going to conduct a whistleblowing investigation and how long that's going to take. And just to make sure we can put our arms around these people as well, because again, empathy plays such a vital part in this. And again, this is about improving organizational culture, governance, and it's about reducing the risk of wrongdoing. So there's the business benefits and there's the personal benefits associated with that. So Axel, if we can just pop down to the next slide very briefly. As you can see, or hopefully you can see, this falls into the TC 309 or the 37,000 group of standards. You can see the picture in there. It's received an award recently with, I think Axel's in that photo as well, looking very dapper. And it's not just about whistleblowing, but this aligns to governance standards, it aligns to compliance standards, it aligns to bribery, fraud, conflict of interest, and many other standards in this space. There's standards being built for modern day slavery, for diversity inclusion. Okay, and whistleblowing is an underlying mechanism that supports all of these, which we can see briefly in the next slide. Actually, if you can move across to that, please. Now, I am going relatively quickly, so we've got time for Q&A, and I will share these slides at the end as well. And I'm always happy to jump on a call afterwards. I will talk about whistleblowing 24/7, so feel free to reach out at any time. But what we really see within here is that whistleblowing is a big part of management within compliance, and it certainly supports governance within an organisation. You can see how this aligns into some of the other standards within that series as well. I think one of the key areas from a strategic perspective that TC 309 is looking at right now is how we focus on integrated governance and compliance. So whether we're fighting bribery, corruption, other areas of wrongdoing from bullying, harassment to money laundering, whistleblowing can play a key component within that as well. I think, actually, if we skip past the next one, we can send these slides on, so I won't dry read through the slides. But what I would like to do is talk about the scope of the whistleblowing program, okay? Because I think this is important as well. There are lofty ideals sometimes, and it's very easy to try and boil the ocean. But I think, especially for organisations that are trying to get established within whistleblowing, it's about setting the scope at the right level. And this is one of the beauty of ISO 37002, because it provides guidance. It's not telling you what you must do, but it's telling you what you could do or what you should do. Organisations can set the scope, and at a minimum, it should align to legislation, but actually you can extend further than that as well. So one of my arguments in particular, especially as we talk so much about anonymity, is we should support anonymity within internal reporting systems, because it's about the evidence, it's about the information that's provided from that person and nothing else. If you build empathy with that person, they may choose to make themselves known over time, but you shouldn't discount information just because it's come from an anonymous source, any more than you should discount information if it's come from somebody who's potentially got a bad reputation, because sometimes they actually know where the wrongdoing's happening better than others. It really is about focusing in on what is wrong there. So from an organizational perspective, you can extend further than just the basics. You can provide wider protection. So whereas in Trinidad Tobago, there's not a lot of clarity around the protection for anonymous whistleblowers, as an organization, you can certainly do your best to try and protect an anonymous whistleblower. And I'll show you how as we go further into these slides as well. So I just want to look at this briefly. If we go on to the next slide, I'm not going to jump too much into each of these pieces of legislation, but just looking at it from a CARICOM region perspective as well. For full members, there's several different whistleblowing laws within there, including the Trinidad Tobago whistleblower protection laws, which Axel went into some great detail on earlier on. But there's a lot of differences between those as well. And what I chose to do is, if we go to the next slide, I've just pulled out 3 examples here because I want to take these and then apply them to how ISO 37002 can be applied. So we started with, if we look at Guyana, so Guyana, the 2018 legislation emphasizes protecting the confidentiality of a whistleblower's identity. It doesn't explicitly prohibit anonymous disclosures, but the focus is upon protecting information that identifies or may lead to identification of the person who made the disclosure. So it could allow for anonymous reports, might not allow for anonymous reports, but as an organisation under ISO 37002, you've actually got the ability to do that, because one of the things that organisations can do is they can become the whistleblower sometimes as well. So once you've been made aware of information, there's nothing to stop an organisation saying, okay, well, we'll be known as the organisation, or I'll be known as the whistleblower, as a case handler, and I'll provide that to the authorities instead, because the evidence sits in your hands there. So there are ways to still protect those people in the background and utilise that information yourself. The Jamaican legislation is more interesting. Anonymous disclosures are accepted, but are not protected by the Act. So saying you can make an anonymous disclosure, but we're not going to protect you. But again, using ISO 37002, you can still do your best to protect that whistleblower as an organisation. And again, you might choose to become the whistleblower on behalf of somebody that doesn't wish to be known or have themselves known later on. Or if they haven't provided, if you don't know who they are and you can't work out who they are, and you shouldn't try to work out who they are, then again, you can become that whistleblower. You can do some good with that information. And then obviously there's a Trinidad and Tobago, which explicitly addresses anonymous disclosures. And again, there's lots of different subsections. So section 7.2 states, subject to subsection 3, a whistleblowing reporting officer, a whistleblowing reports unit may receive and process an anonymous disclosure and may take the disclosure into account in determining whether improper conduct has occurred. So they're not saying you can't deliver an anonymous report, but they're saying where the identity of a person who makes an anonymous disclosure becomes known, then that will be deemed a protected disclosure, which implies that if they're anonymous, then they don't get those whistleblower protections, similar to the Jamaican law as well. But going back to how you set the scope within an ISO 37002 policy or an aligned policy, you can still provide as much protection as possible, although with the caveat, of course, that if you don't know who that person is, you can't protect them. Actually, if you can go to the next slide, please. So we start with the policy. Everything starts with a good policy, but policies have to be backed up, of course. But in this case, a zero tolerance to detriment can make a very big difference, okay? So whether a person is known or whether somebody is suspected to have been the whistleblower, even if nobody knows and the whistleblower team doesn't know, people should know that if they've suffered some form of retaliation because somebody suspected that they were the whistleblower, or even if they are the whistleblower, then that won't be tolerated. And again, there's an element of protection that goes with that because they need to make themselves known to some level at that stage. The channels and the approach to reporting, so allow for anonymous reports. It's easy to have anonymous reports. It's easy to have two-way communication. And I get very frustrated when I see organisations talk about, if you remain anonymous, it may be harder to investigate this. No, it's not. If I call myself Bob Smith instead of Andrew Samuels, I'm supposedly known, but it's only as good as the way that I choose to communicate with that and how easy the system is set up there. And again, with the approach to anonymity, as we spoke about earlier on, must be clear. You can't protect a person if you don't know who they are, except for the zero tolerance clause that's been built into that. And obviously, it's how you communicate with that person throughout the course of a whistleblowing investigation as well. As a commitment to follow up on all concerns and feedback in line with data protection and legal requirements. So once information has been delivered to an organisation, it can't be ignored. Okay, plausible deniability does not make its way into any of the new legislations anymore, whether it's the EU directive, UK whistleblowing laws. Okay, if you know about it, you know about it. You need to do something about it. And if the source was anonymous, as an organisation, that does not negate your need to act upon that information. Can't make that clear enough. I think some people try and use that as a reason not to follow up on information that's been provided. So if we can just go on to the next slide, please, and I'm conscious of the time, so I'll try and keep this part as brief as possible as well. Again, I'm happy to talk about this offline. But when we went back to the ISO standard, reporting, assessing, addressing, and concluding, what we can see is we've almost got two channels down there. So we look at the actual concern itself, but at the same time, we also look at preventing detriment to the whistleblower and other stakeholders involved in that. And if you remember at the start of my presentation, when I spoke to the fact that an organisation is only protected when its people are protected, this is clear here, this is clear within this process, okay? And over time, this is a great way to provide continual learning for an organisation, and to provide what we call a defensible position as well. So where there are new whistleblowing laws, organisations really want to be able to demonstrate that they have taken reasonable measures to investigate the concern and to protect the whistleblower or the person who has raised that concern, and other stakeholders are involved in that as well. And following this process, using the right systems and the right processes, you will always have a defensible position that is documented and time-stamped and demonstrates that you're actually committed to following up on your policy, and it's more than just nice words. So finally, Axel and I were talking about this before we put the presentations together. I'll do this very quickly. There's a lot of hype around the AI in whistleblowing right now, and there's a lot of hype around AI just in general around technology now. So I cannot stress this enough. I might have repeated myself once or twice. Whistleblowing is about utilizing human intelligence, and it's built on empathy and trust. Okay, it's about the facts. So AI is all the talk right now, but they're primarily focused around chatbot solutions. I don't know about other people on the line. I find myself quite frustrated when I find myself talking to a chatbot because it's not really answering my question. It's not actively listening to what I do. There's no empathy in that. You know, it's about being able to ask the right questions as well. For a chatbot to say, "Are you okay?" It doesn't really feel like, you know, "Are you okay? How do you feel today?" Having that conversation, building that rapport, using your tone of voice, getting to know the person you're talking to. And for the foreseeable future, at least the next decade, it will never take away the need for human review and approval. Now, at some point that may change. I never say never. I can't quite see how that would happen yet. However, one of the things that I found very early on when I started working on regulatory programs at HSBC, when I first got involved in the whistleblower program, was that part of the money laundering program that also formed a part of the deferred prosecution agreement came down to the fact that the bank couldn't demonstrate that they were doing the right thing, not that they were necessarily doing the wrong thing as well. And I think it's really important to make sure that you understand the technology, you understand how this works, you can articulate that, and you understand what you're doing. I think right now a lot of people don't necessarily understand how AI works. So ask a few questions as you're looking at technology. Is it proportionate to the size and complexity of my organization? Do I understand how this works? Will this build trust with our people? And will this build trust with regulators and other stakeholders? And if you can't answer those questions in a positive light, then it's maybe not the right technology or the right solution for you at this point in time. If we go on to the final slide, AI, the opportunity. It can be used to impartially and objectively undertake an initial triage with the right tools. I'm happy to demonstrate how that can be done. And that can actually reduce the time for humans to be able to make a decision based upon that process. It can be used in an integrated governance, risk and compliance program to help identify risks and trends across an organisation much sooner, using historic point-in-time data and utilising open source intelligence to see the threats that are coming through that could impact an organisation of your size, sector, complexity. And it can be used to help create insights and recommendations for control improvements within your compliance function as well. But ultimately, it will require a human review, understanding and sign-off. And whistleblowers, you know, for the foreseeable future, will be better placed to build trust and empathy with another human. AI can be a process within this, but it's not the entire solution. So I'm going to finish it up very quickly there because I know we're over time. I'm sure there's going to be some questions. So actually, if I hand that back to you.
All right, great. Thank you very much, Andrew. And I would like to open it up. I don't see any questions in the Q&A space. Let me just double check that. Yeah, no, I don't see any questions. So if you have any questions or if you would like to speak up, please feel free to speak up and we can invite you to put your question. Um, I can also present to you one more element, which is the services that how we integrate this in dialogue solutions, where you can see that we have a subscription service where you have workplace mediation. So for workplace disputes, we offer mediation and or whistleblowing. So in one subscription, you have both services. In practice, it turns out that some whistleblowing aspects and are actually also about disputes. And if that involves a dispute, so that could be then practically and constructively handled within the mediation service. But uh, so if it's a wrongdoing, then we have the technology for persons to whistleblow. And if you already have the technology, then we have the actual whistleblowing triage service together with the policy and the training that is required. Just think that in any situation, in order to implement a system, you need the policy, the training, and the technology. You need to put all three things together. If one aspect is not there, the whole system will fall down. And so that is why having an integrated approach, we think is very useful. And we estimate that on average, it takes about 2 hours to properly investigate a case in order to determine what to do next. And the result of that process then is in a defensible, documented, robust procedure that withstands the scrutiny and that is efficient. If you hand it over to legal investigation, for example, then you will have a well-documented case that will reduce your legal fees because you don't have to go in circles to find out what you were supposed to find out to begin with. And so you may have an officer yourself in the organization, and we are supporting that officer. We may act as your officer, but our overall aim is to enable organizations to generate value in an ethical and sustainable manner. And in doing that, constructive workplace dispute resolution as well as whistleblowing are two parts that are complemented. And we believe the most financially efficient way is to do this on a subscription basis because you get top level professionals supporting you, not only the technology bit, which is really honestly it's the cheapest bit, but to actually have uh, cases done and properly prepared. Because a lot of cases, in our experience, what happens is that if you are wrong on the procedure, if you're messing up the process, the whole case you're not going to earn the benefits of the whistleblowing process itself. And you may create more trouble for too many people and actually damage the process. And so therefore, we think good process is absolutely vital in this process. Okay. Donna, can I invite you to reflect on any aspects of these things or make concluding remarks? And then Andrew also. I think we have, if there are any questions and invitations from people, then you're most welcome to speak up or to post your questions. And otherwise, we're going to have a closing round of comments from the presenters. And then we thank you and we wait for you to contact us.
One of the things I wanted to do, Axel, and thanks for circling back to me, is to share that article that I quoted from, just briefly, from Transparency International, from policy to practice, as it also, in terms of getting to this point of putting in a system, has reference material from a lot of hard work that has been done by TI on best practice principles and self-assessment frameworks that can be used to assess an organization's current position and how they move forward, even before they get into the thought of automating and involving external parties, etc. So I think it will dovetail and work nicely with what we have covered today. And so I'm going to share the link to that article. And I invite our participants to go to that article, read it, and all of the other reference materials that it would take you to. I think it will really broaden your understanding of the whole whistleblower. I'm not going to call it a challenge. That's the word that's coming to mind. But the unfolding of that system and this new journey that we're on, unfamiliar journey, but it's one I think that is worthwhile and worth putting in place, both for its hard and soft benefits.
Okay, excellent. Well, we're gonna. Everybody who is registered will receive an email to this, and those who watch it after this event, they will be able to also download this material. So thank you. That's great. And Andrew.
Thank you. Always good to bring it home. And again, to Donna and to Axel, thank you so much for the presentations. And I think, just to finish off, whistleblowing is a force for good. Okay. It's challenging because people have misconceptions about what whistleblowing is and who whistleblowers are. I think organizations also have misconceptions about how challenging whistleblowing can be. Whistleblowing is one of the most cost-effective mechanisms for your first-line support within an organization. I think at some stage, Donna, it's a great opportunity to explore how do we find the businesses that take whistleblowing well and how do we promote them so that consumers and investors feel safer going to them, because that's one of the ways that I think we can change the narrative on whistleblowing as well. I remember saying, well, over 10 years ago, I think it's going to take 30 years to really change the perception of what whistleblowing is. I still think it might take that long, but I think we're finding better ways to do that as well. It's a fight worth having because ultimately, it's not just about protecting people, it's about protecting the environment, it's about protecting our purpose. And we sometimes look at it from different perspectives, but ultimately we've got to find that way to make organizations realize that to have a whistleblowing program in place is as vital to its success as having an occupational health and safety program in place. And I'll finish up on this thought. 30 years ago, people would never walk past a fire escape that was blocked by boxes and think, I should move those boxes. Okay, but now they do. And that's taken quite some time to get to that point as well. But now it's just ingrained in people's DNA that it's common sense to move boxes from the front of a fire door. And I'd love to get to that point. Donna, we can have a discussion one day about who's got loftier ideals, perhaps. But I'd love to get to that point one day where whistleblowing is baked into the DNA of every single organization, that it's just done without people thinking about it. Okay. It's a long way down the road, but I think it's something that certainly gets me out of bed in the morning and helps me enjoy what I do for a living as well. So I'll leave it on that. And I wish everyone a really good day.
Okay. Great. Well, thank you both very much. My concluding thought really is when I go back 15 years ago when we were first drafting these policies within the Caribbean, and because we had this regional case study with regional toolkits, with regional everything, working with the IDB, including with transparency and the training and that everything. When I then saw the standard itself, and I said, "Oh my God, I wish I had this thing." Because the amount of time we spend in writing terms of reference for people and arguing and convincing people what should the board do, what should management do, where should it be located, how do you constitute this, how do you respond, all those things are actually almost literally copy and paste kind of thing. That the problem has been solved, and it is really about creating space to have human interaction and working as a leader in the organization to transform the culture so that the organization can really achieve its full potential. So thank you all very much. Thank you, Donna. Thank you, Andrew. Thank you to all the participants. And we'll be in touch, and we look forward to hearing from you. Thank you. Bye-bye.
Bye-bye.